Good morning once again.
Morning.
I hope you've had a good morning or you're having a good morning. We are just going to start our training today. You can see, I'm going to be sharing my screen, as you can see there. And today's course is HRLAW Kenya, and we are going to tackle a number of things. Let me move my slide. I don't know why it's not moving. All right. So okay. Today's course is about mastering the essentials of employment law in Kenya. I know my audience today is made up of HR professionals who are seeking to enhance their knowledge and keep up to date on the different trends that are emerging in the HR environment. My slide is not moving. I don't know why. Give me a moment. I'm trying to move my slide. I don't know why it's not moving. All right, it's now moving. Thank you. So our course objectives. By the end of this course, we hope that the attendants will understand the key employment laws and the legal frameworks in Kenya, explore compliance requirements for hiring contracts and workplace policies, address terminal laws, redundancy, and legal dispute resolution. We also hope that you'll gain knowledge on emerging trends like remote legalities, AI in HR, and green HR compliance. I know that the last point is a bit new in the HR sector, but we are going to explore. Also, we hope to strengthen the HR policies to align with legal expectations and best practices. My name is Maureen Alinaite. I am the trainer of the day. You don't really have to remember that one. So, this course is divided into 3 sessions. In the first session, we are going to tackle employment law and compliance, and we'll have an overview of Kenyan labor laws, which I know most of you are familiar with, workplace policies and hiring regulations. We also are going to explore termination, redundancy, and dispute resolution. We're going to have a look at how to handle lawful termination, redundancy procedures, employee rights, and resolving workplace disputes. We'll also look at the emerging HR legal trends, where we will tackle hybrid work legalities, AI-driven HR compliance, and sustainable green HR policies. So, as HR professionals, I am sure that you know the backbone of all employment laws in Kenya is the Constitution, the Kenya Constitution of 2010. We also have the Employment Act of 2007, which I know you are very conversant with, but we are going to delve into it a little bit. We also have the Labor Relations Act of 2007. I beg your pardon, Labor Relations Act of 2007. We have Occupational Safety and Health Act of 2007. We have the Work Injuries Benefits Act, which is commonly known as WIBA. It's also an act of 2007. We have the Industrial Training Act. We also have the National Social Security Fund Act, commonly known as the NSSF Act. That one, we also have the new one. Sorry, I had written it as the National Hospital Insurance Fund Act, but we have the new one, which is commonly known as the HRLAW, which has raised a lot of debate in Kenya recently, which is the National Health Insurance Act. And then we have the Persons with Disabilities Act, which also prescribes how persons living with disabilities are supposed to be treated in workplaces. So in the Constitution, under Article 30, we have a provision stopping anybody, rather giving the rights to everybody to have freedom from forced labor. This is in line with the human rights, with the global human rights, because we all know in Africa, there's a time where we had forced labor in form of slavery by our colonizers. And in order for the country, for the government to protect its citizens, they had to put an article in the Constitution giving freedom to every citizen of Kenya from forced labor. We also have Article 41, which deals with the rights to fair labor practices. This article is the basis under which some of the acts that we are going to be discussing were established, just to strengthen and to give, how do I say it? To give a practical sense of this right. We also have the right to join and participate in trade unions. This is established in the Constitution. We also have equal pay for equal work. This one, we have a big debate on it, but it is established by the Constitution of Kenya, and it is a mandatory requirement for all employers in the nation to follow. We also have the Constitution establishing non-discrimination on the basis of race, sex, pregnancy, and disability. We have a little bit of challenges in maintaining and enforcing this part of the Constitution. I know in many workplaces, but we will see how to deal with that during this training. Now, after the Constitution, because I had told you guys before that the Constitution just lays the basis for most of the laws in Kenya. That is why in recent times, for example, when they tried or when they were repealing the NHIF Act, we had a lot of advocates going to the Supreme Court to challenge the constitutionality of that repeal. And then when the HRLAW was established, we also had advocates going to the courts to actually challenge the legality. They were challenging and asking, is it constitutional for this to be done? So if something is, any law that is not based on the Constitution will automatically be challenged. But of course, the court found that it was constitutional, and that is why we have it right now. So based on the Constitution, our drafters went to Parliament and they passed the Employment Act in 2007. And the Employment Act establishes some requirements for workers, or rather employees and employers, in the employee-employer relationship. And one of the established requirement is for every employee to have a written contract. And this should be done within 2 months from the date of starting work. This has changed. This has actually helped a lot of people, because before, You would find somebody works for an employer for a number of years, and when they are finally terminated or when the relationship comes to an end, when they go to the court, they have no basis. They do not have a contract. As HR professionals, this is your number one duty. When you have gone through the whole process, the recruitment process, and you finally get a suitable candidate, the first thing to do is give them a written contract. It is a requirement by the law. If you don't do that, you could be in trouble if that employee knows their rights. The Employment Act also establishes minimum wage and a fair remuneration. Why the minimum wage? We always see on the Labor Day when I know it's a bit political, but whenever there is Labor Day, the employees expect a raise in salary or in the minimum wage. They're always asking, what is the government giving us this year? Like this year, I think they did not increase the minimum wage, and people really complain. They're like, they did not increase our minimum wage. We wanted more money. But at the end of the day, it is the employer who is paying this money. Why the minimum wage? It is set so that people are not exploited, because many a times, of course, in law, we say willing buyer, willing seller. The parties to a contract decide the terms of the contract. So the drafters of the law saw it fit to set this up because many people were being misused. They were being underpaid. And then when it would go to court or any office, they would say, I gave you a salary, you accepted to work. So the government saw it fit to protect its citizens from exploitation. That is why they established the minimum wage and fair remuneration. Fair remuneration means the work that you do should be commensurate with the salary that you paid, or rather the wages that you receive for that particular work. The Employment Act also establishes maximum working hours. Most workplaces give contracts where people work a maximum of 48 hours a week, but the stretch is 52 hours per week. Remember, the Employment Act just establishes the bare minimum of what somebody's contract or rights should look like. So if you work maybe 50 hours a week and somebody else works 48 hours a week, it is the policy of different companies that comes into play. You cannot go and now challenge your boss and say, I want to work 48 hours a week. So the maximum is 52 hours per week, or 60 hours for the night workers, as established by the Employment Act. And this also brings us to the point of any hours worked outside the contract hours have to be paid. That's where you hear something like overtime, I have to be paid overtime. And most workers claim that, especially when the contract has been terminated. When they are working, they have no problem because they're being paid. But at the point where the contract gets terminated, that's when they remember, oh, I worked for 5 years and I worked overtime. I was not paid for it. So they now come to complain to the unions, to the labor officers, and even to the court, claiming the hours that they worked and were not paid for. The Employment Act also establishes annual leave, which is at least 21 working days with full pay, and you can add 7 more days with half pay. Why? It recognizes the fact that humans need to rest from work, because imagine you're working in a place not 24 hours, 52 hours a week for the whole year without rest. It recognizes that humans need to rest from the normal, like the everyday work. Though some people opt not to take their leave, it is not proper for them not to take their leave, because if they don't take their leave, that means you have to pay them double for that month. We experience that especially in the hotel sector, where you find maybe there's a high season and people have not had the opportunity to take their leave. It has changed because workers now know their rights. I remember when I was working a few years ago, when I was working for somebody, we used not to take leave for some reason. And it's interesting because it was a law firm. And then at the end of the year, they would calculate our dues and then say, we are paying you in lieu of leave. But when you look at the pay slip in December, it wasn't double. We were supposed to receive double salary. It wasn't double. So it happened the first year, I was still new in the workplace. Then in the second year, I complained. I told them, I'm expecting double salary in December. Why am I getting less than what I'm expecting? Of course, it caused an appraising in the office. Now everybody demanded for that. They had to pay me my money, and they tried to tell me, oh, you can just keep it quiet. I'm like, no, we are advocates. Why are we not following the law? So in the end, they paid me my money, but in that same year, I left that workplace because, I mean, I was telling people their rights and they didn't like it. Maternity leave, 3 months with full pay. This gives time to the mothers, the new mothers, to bond with their children. And in some places, it's actually unfair when they are advertising, which we will talk about. They say we want a male worker because deep down, they know the ladies will take 3 months leave and they have to pay them for that. So people were being exploited. I'm told in the past, they were given only 30 days. Imagine 30 days. If you are a mother, you know how fast 30 days can fly. And some people were even forced to go back to work with their children. It was difficult. So with the new act, at least they were given more time with the newborns. We also have paternity leave, which is 2 weeks with full pay. This is also given to new fathers. The debate normally is, what if somebody has more than one wife, as the norm is in Kenya? Okay, not the norm, but it happens. What if somebody, for example, for our Muslim brothers and sisters, somebody has a right to have 4 wives. So if all the 4 wives give birth in the same year, how much paternity leave will the man be granted? That's a subject of discussion, a subject of debate, sorry. But in these times, we always see when somebody is applying for a job, they are asked if they have a spouse. So the one who is recorded in the employment record is the one for whom the man is entitled to take paternity leave. Every employee is entitled to notice of termination, and the Employment Act sets the bare minimum, which is 1 month or 1 month's pay in lieu of the notice. However, we have some contracts which stipulate that they have to be given 3 months. Remember, we said the Employment Act just establishes the bare minimum, 3 months notice. We even have other collective bargaining agreements that stipulate 4 months notice when you want to terminate an employee. Every employee is also entitled to a certificate of service after leaving employment. It doesn't matter how that person left, whether they served well or not, whether they were terminated or not, they are entitled to a certificate of service. We now move on to the Labor Relations Act. The Labor Relations Act establishes the right to freedom to join or form trade unions. When this was just passed, many employers fought their workers, their employees. They didn't want them to join trade unions because they now had the power to bargain for higher pay, for fairer working conditions and all that. There were several cases, especially after the establishment of the Employment Act, or Employment and Labor Relations Court. There were several cases of people who were dismissed from work because they had joined trade unions. It was quite unfair, but these days people have embraced it, employers have embraced it, and they actually allow their workers to join trade unions. The Labor Relations Act also establishes the right to participate in union activities, whereby employees can now be voted into office, and in case of organized legal strikes, they can participate in that. We have had an actual challenge of teachers and doctors almost every year. They participate in these union activities, which include strikes. I know it's a bit challenging for the employer and for the people to whom service is being rendered, but it is necessary because it is their right. The Act also establishes, it protects against victimization for union involvement. So as an employer, you cannot victimize your employee because they participated, or rather they were voted as president of a certain union and you don't like it. No, the Act protects them from that. The Act also establishes the right to collective bargaining. We can see the teachers actually really enforce this right. They enjoy this right. They make sure that they state their terms. The teachers, the doctors, we also have the hoteliers these days who actually have those collective bargaining agreements that assist them in getting the bare minimum. Because we live in a world that is always changing in terms of finances, especially when we experience recessions. So there's a need to always have a force of togetherness to bargain for better, because even the conditions of work keep changing. The Act also establishes the rights to strike and following due legal procedure. For example, we always say, I'm going to keep using the example of the doctors and the teachers. They always give notice to the government. They say, if you do not do this, we are going to go on strike. They give like a week. And then when that week passes, they actually go on strike. It is important for that notice to be given so that the employer can prepare themselves. Rather, they can even have time to do what the employee is demanding. But this has to be done legally. They have to follow the procedure. We now move on to the Labor Institutions Act. The Labor Institutions Act establishes avenues through which labor-related disputes can be resolved. And this brings us to the area of access to labor justice. The first point of contact that we have, which employees are actually now taking advantage of, is the labor officer. We find at the county level, there's always a labor officer that is in place to listen to the disputes of the employee. Like in the area where I live, they actually write letters on behalf of employees. Like if somebody has been terminated or they are dissatisfied, they approach the labor officer and the labor officer writes a letter to the employer, and before they actually move on to the next step. Before, people did not really recognize the labor officers. They quickly used to run to the next avenue, which is the Employment and Labor Relations Court. But they now found that they spend so many years in the court. They spend a lot of money in the court, in the justice process. Remember, advocates are not cheap. So they have finally come to the awareness that the labor officer can even be able to solve their issue in a very short time. So they are actually exploring that. We obviously have the Employment and Labor Relations Court, which is the court that gives justice to both the employer and the employee. When it just started, they used to call it the employees court because most times judgments came out in favor of the employee. But times have changed and the employers have become more aware of the things they're supposed to do so that in case of any disagreement, justice is on their side. They have started keeping better records. They've started giving the leave days. They've started paying in lieu of notice. So the cases have actually reduced in the Labor Relations Court, Employment and Labor Relations Court. The Labor Institutions Act also offers protection from unfair treatment, where we now have labor inspections happening. Yeah. For example, I remember when I was in university, we were given an assignment in our labor law class where we had to visit workplaces and actually we had to inspect and see whether they are following the safety requirements as established by the government. So we have now labor inspections where they come to inspect the workplaces and see whether they are actually safe for the employee, because some people work in hazardous environments and they need to be protected. The Act also establishes dispute resolution mechanisms, as we have seen the labor officer, the Employment and Labor Relations Code, and we also have the trade unions where people can complain and actually have their issues resolved. The Labor Institutions Act also establishes the minimum wage orders, where we have the people in charge of that, the wages councils, for ensuring that the minimum wage actually resonates with the changing times in society, because the economy keeps changing. Things keep getting more expensive, and there's no way employees will be able to afford it unless they are compensated in line with the changing economic times. We have the Occupational Safety and Health Act, which we mostly refer to as OSHA. Excuse me. I'm going to refer to it as OSHA because the name is very long. So the OSHA, which was also enacted in 2007, establishes safety and healthy working conditions. It establishes the right to safety and health working conditions. The reason I'm going through these acts very fast is I know you are aware of these acts. They're acts that you have interacted with. So I'm only pointing out the major provisions of those acts. So the OSHA establishes the right to safety and healthy working conditions. When you go into reading of that act, you realize that the citizens, rather employees, are protected and they have the right to work in a healthy environment. The Act also establishes the right to be informed of workplace hazards. We have people who work in dangerous working conditions. Have you seen these people that, okay, let's give an example, like the KPLC guys who climb up that electricity pole to put the wires. They are informed before they take on the work that is what you're going to be doing. So you are aware that you could fall, right? There are people who work in industries, maybe cement factories and all that. They need to be informed that if you don't do this and that, this could happen. We've seen cases where machines have actually cut people and all that. These are things that employees have a right to be informed of. before they start their work, and to be reminded regularly. That is why you find many notices in, for example, factories. This is maybe saying this is a generator room, don't smoke near this place. The OSHA also establishes the right to have protective gear. An example, we have a factory in the coast. That factory processes cashew nuts, yeah? And in preparation of these cashew nuts, roasting them involves fire. There was a recent expose which revealed that the workers there, mostly women, their fingers were burnt because they were handling these cashew nuts without heat protection gear. It was really bad. The pictures were really, really bad. I don't think they actually sued the company. I don't know why. But this act, the OSHA, actually gives them that right. We also have people who work in dirty places. They have a right to have protective gear. Otherwise, they could be sick, like people who work in salt processing plants. The salt can actually eat up their bodies. So the act is there to protect the workers from this kind of workplaces. The OSHA also establishes the right to training on health and safety. There are other places. There's a place I visited recently where they had a fire marshal on site. This establishment actually took time to train a worker in that establishment so that in case of fire, they have somebody who can save the day. I don't know if you have that in your workplace, or do you have to call 911? Do you have to call the police and then you're told the fire marshals are somewhere very far, they cannot arrive? So as an HR professional, you should advise your employer that it is important to have the employees trained on health and safety procedures. It also establishes the right to report hazards or unsafe conditions. In case an employee realizes that there is a hazard in the workplace, they have the right to actually report this to the officers, to the council, sorry, so that they can come and ensure that that workplace is safe for the people who are working there. It also establishes the right to have a medical examination for hazardous work. For example, people who work in processing plants, cement, and all the other plants that involve a lot of hazard, toxins, the air there. Sometimes you pass and it's really, really bad. So imagine somebody working there 48 hours in a week. That means they are exposed to hazardous fumes and they could actually get sick. So they have a right to have a medical examination in case they are working in those environments. Now, we move on to the famous WIBA, Work Injury Benefits Act of 2007. Before 2007, many people would get injured at workplaces and it would just be rubbished. Like, who cares? But with the new laws, we still say new. It's some years later, but we still say new. At least there is a way they can be compensated for work-related injuries, for injuries that happen at workplaces. So it establishes the compensation for work-related injuries or diseases, like the people who are talking about who work in hazardous places. They could develop a lung problem and then they need medication for a very long time. So the employer would now have to compensate them for that injury, that disease, sorry. We have seen people getting injured at work A very interesting one that I dealt with a few years ago was in a sugarcane plantation. Somebody went to cut the sugarcane. He was working for a sugar factory, and then a snake bit him during the exercise of cutting sugarcane. So he now went to court and sued the employer for the snake biting him while he was cutting the sugarcane. It was neither here or there. He was compensated, of course. The WIBA also establishes the right of an employee being paid for medical expenses for workplace accidents. There are people who get accidents at work and then they are bedridden for the rest of their life. It is sad, but there is a way the system has made it where the employer now has to pay the medical expenses for such kind of accidents. Then it also establishes the right to report accidents without victimization. For example, you saw something happen and maybe it didn't happen to you. It happened maybe to your colleague. You have a right to report this, and the employer is not supposed to victimize you for reporting accidents that happen at workplaces. Compensation to dependents if a worker dies due to work-related causes. The other day we had, last year, I think it was last year or the other year, yeah, last year, we had floods in the coast. And there is actually a KRA worker they were driving down from the border, Lunga Lunga, and then the car was swept away by the floods and he died. So in that case, the government has no option but to compensate the dependents of this employee because they died during the course of their work, in the course of their work. We have several even in the construction industry, even in the hotels, where people die during work. So the dependents have a right to be compensated. We have the Industrial Training Act, Cap 237, and it gives the right of access to trainings and apprenticeship. This one is very, very clear. It also gives the right to promotion of skill development, whereby the employees have the rights. For example, you see people taking study leave, yeah? Mostly happens with government workers. They're very lucky. They even take leave for 2 years, go and enhance their skills, and they come back to work. So it is a right that has been established by this act. Employers must contribute to training levy, which benefits the employee. Now, it is imagined that the skills that the employee is going to gain in that training are actually going to benefit the employer. That is why this is done. We have the NSSF Act, National Social Security Fund Act of 2013, which establishes mandatory pension contribution by the employer and the employee. Now, why was the NSSF Act enacted? The government realized that when people work and finally retire, they become a burden. We've had something in Kenya called pesa ya wazee. Pesa ya wazee is money that the government gives out every month to those people who are old, who don't have any money at all. And they're given 2,000 shillings, I think, per year. They make a line at the bank and all that. It's hectic. So the government saw it fit for people to prepare for retirement. I know people, especially in this part of the world, they don't like to save for retirement. They say, tomorrow is not guaranteed, so why should I save? So the government forces them to save for their old age, which I think is a good thing, though sometimes the fund is misused by people who do not appreciate it, but it has helped many people have a better retirement. The Act also establishes the right to retirement because of invalidity or, I beg your pardon, it establishes the right to retirement because of invalidity. Sometimes people are sick and they cannot continue with work. So they have no option but to retire. It also recognizes that you don't really have to work until the required retirement age. Though we see other people right now, they don't like to retire at all. Don't like to retire. They just want to keep in the system, work, and yet there is a lot of labor, young people coming into the system and they have no work to do because the old ones are not willing to retire. The Act also establishes survivor benefits. For example, if somebody dies before the retirement age, the survivors can still benefit from the money that they saved through the NSSF. The Act also establishes portability of benefits when changing jobs. For example, if I was working for somebody last year and then I moved to another job, the savings that I had in the NSSF will still be moved even when I change jobs. Like it is a saving for me, not for the employer who has employed me at the time. And the employer is supposed to contribute as well. So they do not now take back their contribution because I left that place of work. We have the National Health Insurance Act, which replaced the NHIF Act. Last year, we had a big debate when they established the SHA, the famous or infamous SHA that was established by the government. And people complained. The complaint was, why are they removing the NHIF? Why was that happening? Because money had been misused. We know that debate. I don't want to engage in it. So they now established, it's literally the same thing. It's literally the same thing. It's just that this other one now has an authority that deals with. But yeah, we know its problems. So anyhow, the drafters of the law sought to establish an insurance fund that gives access to medical cover for employees and dependents, which was literally happening in the NHIF. It was the same thing. Contribution by the employer on behalf of the employees. It's just that this time around, the amount being contributed was increased. Yeah, it was increased from what it was when we had the NHIF Act. And that is what people were complaining about. So the employer is supposed to contribute on behalf of the employee, even the employee. So there's a figure that comes from both sides. I experienced this in a bad way when we still had the NHIF Act, where I used to work. They used to give us the pay slip, and the pay slip showed that money was being remitted to NHIF. So when I moved to work for myself, I followed up and realized they had not been contributing the money. The money was being deducted from my money, my pay, but never submitted to the fund, which was a very bad thing. But anyway, now I had to register to pay that money and all that. So what do we have in the SHA today? We have an option of paying for a whole year. You can pay for a whole year so you can enjoy the insurance. This new SHA, it provides for medical cover in public and some private hospitals. People at first really didn't like it because they said the government is not paying. Personally, I have not used the SHA, so I am not able to justify it or complain about it. But I've had some people who have actually been assisted by this SHA, especially when it comes to checkups, because they say they are not able to give you the medication, but they can do all the checkups, and especially in the government hospitals, the public hospitals. So it's important for you as an HR professional to make sure that all your employees are registered on the SHA. We now move to the Persons with Disabilities Act of 2003, which establishes the right to non-discrimination in hiring, promotion, and training. We actually see when jobs are being advertised, especially government jobs, they give a priority to persons living with disabilities. It is a way of encouraging them, of assimilating them into the system because they are enabled differently. When you look at the NGOs, they don't like using the persons with disabilities. They say differently enabled, but the act is stated the way it is for a reason. The act also establishes a right to reasonable accommodation at workplaces. In recent times, we've seen even when you are maybe putting your business on Google, they ask you if your place is designed in a way that it can accommodate people with disabilities. That is why you've seen in recent times, we have the staircase and then we have an elevated, how do they call it? A place where a wheelchair, somebody can access the workplace with a wheelchair. So when you're designing accommodation at workplaces, you need to think that maybe one day you will have a person who is enabled differently and they will need to access a certain accommodation. So you make provision for that. The Act also establishes the right to affirmative action and protection from unfair dismissal. Of course, they can participate in say, if there's positions that are up for maybe promotion, you don't have to discriminate against them because of their disability. We also have tax incentives for employers who hire people with disabilities. Even the people with disabilities themselves, especially the ones who work in the government, you find that they have tax holidays, yeah? They don't pay some tax because they are people living with disabilities. Now, we have run through the legal framework of the labor laws, all right? We were going through all of them. We are now going to zero down to the next part of the legal frameworks that is normally a headache to HR professionals. Because as HR practitioners, you are in charge of hiring and firing. The hiring is fun. The firing is not fun. Why? Because the law has made it a little bit difficult for you to do your work. But if you know exactly how to do it, it will be fun. So we are now going to that part, termination of employment. Part 4 of the Employment Act establishes scenarios where termination can occur. Termination of employment is, we can say, is when the employment comes to an end. The relationship between an employer and an employee comes to an end. The first example of how termination can occur is through automatic lapse of term contracts. We have different types of contracts. We have the daily ones, we have the weekly ones, we have the monthly ones, and then we have maybe the annual ones or even 5 years. So if somebody has a contract for a month or two, when that contract time comes to an end, termination automatically happens. And termination can happen through express in written form or by implied. It can be implied. All right, like the contract comes to an end and then you just don't show up for work the next day. Termination can also occur when either of the parties cannot go on with the contract. For example, if there is a misconduct and the employer feels like, no, I'm not having you anymore, I have to let you go. We'll see different examples. It can also happen when there is redundancy. We'll talk about that. And then it can also happen through an act of God, which we also always in law refer to as force majeure. Like maybe somebody is ill to the point that they cannot continue with work, or if they die, automatically that contract is terminated. We'll look a little bit on the subject of redundancy. Redundancy refers to a situation where the employee is lawfully terminated from employment because their position is no longer needed and not due to their fault or conduct. We normally see, sometimes this happens. It happened a lot during the COVID. People were laid off, their positions were no longer needed. Section 2 of the Employment Act defines redundancy as the loss of employment, job, or career by involuntary means through no fault of the employee, involving termination of the employment at the initiative of the employer where the service of an employee are superfluous. The easier definition is up there. So when does redundancy happen? Mostly we find businesses can decide to restructure. So in terms of restructuring, redundancy can occur. They can decide we don't need this position anymore. Then sometimes businesses can downsize and they cut off some people. During mergers and acquisitions, like when, say, two businesses come together, you are an HR professional in one business and the other one also has an HR professional. So when they merge, they do not have space for two HR managers. So they decide to do away with one. Or acquisitions, one business buys another and they decide we had 50 people, you had 50 people, but we can only now sustain 70. So they do away with the 30. Businesses close. Biashara ikikata, you close. Then automatically people are rendered redundant. And then we have this new one, adoption of new technology. We have this happening a lot because, I mean, machines can now do the work. If your company decides they're no longer using this and that, they have now technology that can actually do all this, redundancy can occur, excuse me. We have economic downtime. We saw the COVID, we saw what COVID did. There was nothing happening everywhere, so people were rendered redundant. Now, what are the rights in case of redundancy? The employee is entitled to notice or pay in lieu of notice. As we said before, 1 month's notice according to the Employment Act. That is the bare minimum. And also that notice will depend on the terms of the contract. If the contract states 3 months, then they will be given notice for 3 months. Then they're entitled to consultation. They can be asked about it, or maybe even be given an option of what they can do if you cannot do this. Like I remember some time back, I was closing down a business, and then I asked one of my employees, okay, you've been in the reception. Apart from reception, what else can you do? And the person told me I can do nothing. So anyway, it wasn't my fault. Then fair selection criteria based on skills, experience, and performance. Before you render somebody redundant, like when choosing who to let go, you have to give priority to people who have the skills, experience, and those who have performed well. Then the employees who are rendered redundant are entitled to 15 days pay for each year of service, which we normally refer to as severance pay. Then they are entitled to their accrued benefits in case there's unpaid leave, in case there's overtime that has not been paid, all the benefits that they had when they were employed, when the work was still going on, they are still entitled. And then finally, they are entitled to a certificate of service. Now, in case of termination, cases of termination which are, apart from the term contract coming to an end or redundancy, there are these other times when you find yourself in a situation where you have to let somebody go. So, in case a term has not come to an end, but one party wants to terminate, they must give notice as prescribed in the contract of employment or in accordance to the Employment Act or in accordance to the collective bargaining agreement. As we have said before, there are some collective bargaining agreements that require that you give 4 months notice. In case you want to terminate somebody, you have to give them that notice in accordance to the CBA. Where notice is not given as prescribed, either party has to pay in lieu of notice. Most times, well, the employer will pay, but most times you find when the employee wants to leave, they don't want to pay the employer. They want to just up and leave. We have few cases where the employer has actually sued an employee for not giving notice. Whether they recovered that amount of money is a subject of another day. An employer has no right to decline resignation of an employee, as it is tantamount to subjecting the employee to servitude, which is contrary to Article 30 of the Constitution of Kenya. Have you ever been given a resignation letter? Do you have the option to refuse it? Of course you cannot, because you cannot force somebody to work. And that is why the Constitution gave us the freedom to, the freedom against forced labor. So if you refuse somebody's resignation, they can actually sue you and they will get a very reasonable compensation for you violating their constitutional rights. Benefits in case of termination. Where somebody's contract is terminated before its due time, they have, what happened? They have to be paid service pay for every year worked, but this is not applicable for persons in pension funds for which the employer is contributing, for example, the NSSF. We also have employees who have a different pension fund where the employer actually contributes to it. It's not applicable in cases of gratuity fund or funds established by the CBA. And it's also not applicable where the employee is part, of course, of the NSSF. Did somebody write in my slide? There's a line that has appeared. I don't know if it's showing in your side. Now, when can lawful termination happen? Lawful termination can happen in case of misconduct. This is one of the reasons why somebody can be terminated according to the Act, and misconduct is established as one of these: absenteeism without leave, intoxication while on duty, negligence of duty, use of abusive language at workplaces, refusing to obey lawful instructions, and then conviction in a court of law. These are the reasons why, as an HR professional, you can terminate somebody's employment before the lapse of their term. What is the procedure if you want to terminate me from work? What is the procedure? First thing, you have to issue warnings in writing. Many a times, you hear somebody was fired and then they were not given warnings. They said, oh yeah, I just gave them verbal warnings. It will not hold in a court of law. So make sure your warnings are in writing. And after the warning, the next step, if the bad behavior continues, you give them a notice to show cause in writing. Notice to show cause why they should not be subjected to a disciplinary hearing. I hope you have disciplinary committees in your workplaces, because it is important. So after the warning, you give them a notice to show cause why they should not be subjected to disciplinary hearing. And in case, and you insist that they must respond in writing. And you give them a specific time within which the response should be received. Say maybe 7 days. If they do not respond, then you subject them to a disciplinary hearing and make sure it actually happens. How will the court know in case of a dispute? How will it know that a disciplinary hearing happened? There have to be minutes of that disciplinary hearing. And at the disciplinary hearing, you have to present that person with the accusations in accordance to the notice to show cause that you wrote. For example, if you wrote me a letter telling me to show cause why I should not be subjected to a disciplinary hearing because I did not come to work for 2 weeks, and then you call me to a disciplinary hearing, and then you're asking me why I did not clean the windows properly, it's not proper, because I'm not being taken through the hearing of what I was given the notice to show cause for. After the hearing, you issue recommendations of the hearing and resolution. Most HR professionals ask people to come for disciplinary hearings when they have already made up the decision to terminate. It happens a lot. And this now, we see it in the court, especially when we are cross-examining the HR professional. An advocate will just ask you a question like, had you already decided to terminate them at the disciplinary hearing? And of course, the HR professional is happy that they were able to fire this person who has been giving them. And it's like, of course, yeah, I had already made up my mind. So you are supposed to attend or to have the disciplinary hearing without bias. Don't make up your mind before actually hearing the person, because that means you have condemned them and they will get compensation. I've seen several cases where people have got compensation just because of that statement from the HR. Yeah, I had already decided I would fire them. After you have made the decision, you communicate the decision in writing to the employee. You make sure your words are clear. I know you know how to write these letters, but I'll tell you again, in accordance with the disciplinary hearing that was held on this day, the committee has resolved to terminate your employment. Then you must include the right to appeal. You must include that in your letter of termination. You have a right to appeal within 14 days. Well, that is the minimum, within 14 days, if you're not satisfied with our decision. So if no appeal comes within 14 days, well and good. If an appeal comes, then you have to listen and give them a chance to explain themselves. So, what avenues do we have in case of dispute? Like, for example, you have terminated somebody and they are not happy with the termination. Where can they go? Number one, they can go to the trade union and complain against the employer and say, I was terminated and I did not like how I was terminated. I do not think it is the right thing that they did. And then the trade union, of course, will write to your employer and inform them of the complaints. And then you can sit down on a table and have the issue resolved. You tell them we fired this person because of this and this, and we actually followed due procedure. If the trade union finds that you are right, of course, the termination will be upheld. The employee can also go to the labor officer, which is actually happening a lot these days. They get demand letters to the employer, and then the employer is actually called to the table. They listen, and they give recommendations to the employer and the employee. If the employee is right, they give recommendations to the employer. If the employer wants to follow those recommendations, well and good. If they do not want to follow the recommendations, they can move to the next place. They can wait to be taken to the next place, which is the Employment and Labor Relations Code. So decisions from the trade union and the labor officer, rather recommendations, not decisions. Recommendations from the trade unions and labor officer can actually be challenged in the court of law, or if you don't really agree with them, you have an avenue, which is the Employment and Labor Relations Court, which now has been, before it was only being had in the High Court level. But nowadays we have the magistrates' courts, which actually listen to these labor disputes. And in the recent times, they have adopted an alternative dispute resolution mechanism in line with the recommendations and the vision of the Honorable Chief Justice, whereby they would rather have the cases sorted out of court. So most times when cases are brought to court, they are referred to a mediator who is an advocate trained. Okay, they don't necessarily have to be an advocate, but most of them are. They are trained to mediate between the employer and the employee so that they can come to an agreement and then they can have the case solved faster. And those recommendations from the mediator, if they come to an agreement, that agreement is taken to the court and it's adopted as a judgment, and it can now be enforced as a decree. Now, that is it on the employment laws, the avenues for dispute resolution as provided in the Employment Acts and all the other acts that we talked about. We are now moving to our third, that was the second, our third part of the discussion. Emerging HR legal trends. As I said in the beginning, we live in an ever-changing world. The world is always evolving. Technology is changing. People are changing. People are getting more they are becoming lazy. It's sad, but people are becoming more lazy. Technology is taking over. And this is affecting the way things are being done in the HR space, in the HR spaces. So we have trends that are emerging in the HR legal spaces, which we are now going to talk about. It is good for you to be aware of this so that you're not caught off guard, because things can change anytime. We had these changes specifically after the COVID-19. It changed a lot in the way we work, in the way we do things, in the way we hire, in the times that we work. A lot changed. So in recent times, we have cyber security, hybrid and remote work legalities. This is something that has really changed in the HR space. For example, right now, we are having a training. You are where you are, I am where I am, but we are speaking to each other. What gives us this opportunity is the change in technology. But in this technology, we find ourselves in a place where we could be exposed to, say, cyber attacks. There's a time I had a training, I was at a conference, and the person who was doing the training, I don't know how they did it, they just wanted to show us how dangerous it can be to work online, like the way we are doing now. Suddenly, somebody was asked for their phone, and their phone now became a medium of transmission. It was now showing all of us in that space, and everybody was shocked. Now, that time, It was in 2021 when the technologies had not really been explored. So as HR professionals, you're going to encounter cyber security threats in the coming years, yeah? Especially when we come to issues of data protection, which is now a new trend, and we have many people actually exploring it and making money out of it. We have AI. It's the now. Artificial intelligence. Somebody the other day asked me, what is AI? I told them it's artificial intelligence, where machines are now thinking on our behalf. What does that mean? Even as lawyers these days, we have had a challenge. People used to come to us, we need this. But now AI is doing for them everything. And then they say, oh yeah, I have my document. I just want you to stamp it. Maybe if you used to charge somebody 100,000 for something, you can now not charge them 100,000. You just have to charge them 20,000 because the AI has done it for them. So as HR practitioners, the AI is now with us. I don't know, those days they used to say what are they called? The aliens. So I don't know if the aliens are now with us, but yeah, AI is now with us, and it will affect the way you do your job as an HR professional. We are also going to be tackling sustainable green HR policies. Yeah, the world is changing and everybody is concerned, especially with the climate changes. This will also affect the way you come up with policies in your workplaces in line with the changing world. So let's talk about hybrid and remote working legalities. We are working online. I am talking to you. You are listening to me. In the old times, we would be in one room. You would have paid transport. You would have paid accommodation and all these things to get this training. But because of the technology, we can now work online. We also have hybrid workspaces whereby you find, yes, you wake up in the morning, you go to your place of work, but the project that you're working on is not in the same place you're working. I have a friend of mine who is an HR professional. She has her own brand. She doesn't have an office, like she doesn't sit at a specific office, but she's able to manage workers of different organizations, hiring, firing, payrolls, and all other legal and statutory deductions and everything. She does that for those, say, 5 companies at the comfort of her home. As an HR professional, how does that affect you? It now shows you that you do not really have to sit in a particular place every day to do the same thing. So how are you going to be able to do it in line with the law? In this particular topic, we are going to address the legal aspect of modern work arrangement where employees work outside a traditional office setting. So you as an HR professional, do you have the option to work offsite? Do you have the option of not coming to your workplace every morning? Does your workplace actually have the option for employees to work from home? Because I've seen others these days, they say you can work in the office 3 days a week and then on the other 2 days you can work from home. Is it necessary for people to come to the workplace every day? The times are changing, and you may also need to change the policies of your workplace. Key legal consideration. Now, The Employment Act may need to be, it will need to be amended. It will need to be amended to accommodate hybrid and remote workplaces, workplace, how do I say it? Because it was designed in an era where people had to report to work. We have the clock-in system where people go to work and then put their fingerprint so that they are recognized as having come to work. So with the new trend, with the new technology, how can we change the Employment Act to accommodate working from home or having a hybrid situation? The Employment Act will need to be changed to structure work hours. For example, we saw, according to the Employment Act, the maximum working hours are 52 hours in a week. So when it comes to hybrid and remote work, how is it going to work? How will you know that I'm working? I'm in my house, I have an assignment. It is interesting that even when people are in the office, they are in office and they're not really working, they're just there. So do we now say, as long as the assignment is done within 2 days, you're considered to have worked? Or must you work every day, even if you're doing it for 2 hours per day, and you conclude the assignment in 2 days, you'll have been considered to have worked? It's an actual challenge. And our drafters will need to actually put it in consideration. I don't know how the government is going to do it, because we have even parliament sessions. They have to go and sit there and vote aye and consume the taxpayers' money, yet it's something they can do online. It's something they can, so they need to have that in their brain so that they can actually structure our working hours. The Employment Act will need to be amended to establish the right to disconnect and ensure work-life balance for remote employees. For example, if I am working for you and I'm working online, I'm supposed to work, say, 8 hours in a day. If my 8 hours are over, as an employer, you should not have the right to call me outside the stipulated working hours. Say I submit an assignment before 5 p.m. Now, since the employer is working at night, they decide, okay, I've seen your assignment, and then they call you at 10 p.m. Is it right? It shouldn't be right. So the employee should have the right to disconnect everything, like kazi imeisha. We even see these days customer care advisors in Safaricom, they work offsite. They are not in the office. So you call the machine, and then the machine sends you to somebody's phone. You actually hear that person, maybe ako kwa shamba, the birds are singing, things are knocking, which used not to happen. And when it comes to time, the 8 hours are over, they should have that right not to pick any phone calls from the employer. Remote workplace safety needs to be considered. For example, how safe is my computer, or how safe is my home when I am working from home? Because we are now in a Zoom meeting. How safe can somebody be able to tell where I am because I am working online? Is it possible for somebody to tell where I am? Of course, it is possible. So how will the employer ensure that their employees are safe, especially when working from home? Technology can mess everything. It's a good thing, but it can mess everything. The drafters of the law really have to consider that. Are we going to be able to install things on our devices that protect us even when we are working from home, from cyber attacks, from physical attacks, because if somebody can trace your location when you're working from home, it's an actual occupational hazard. They also need to I beg your pardon. They also need to consider extending occupational health obligations to the home offices. Yeah, I just talked about cybersecurity, protecting company data and system accessed remotely. For example, we have people working in the banks. Maybe they're in charge of, say, the Visa card. You have your Visa card and then it has a problem. You call the customer care transfers you to their IT specialist. The IT specialist is working from home. They have the computer of the workplace at home. How safe is the company data when that computer is in the home of the employee? In case somebody knows the password of that computer, are they able to access information? Are they able to access the data of the customers of the bank? You know, it can happen because if somebody knows, oh, this is my spouse's laptop, I can use it anytime, for example. I know the password, I know whatever. That password, if that person accesses the information of the bank customers without authority, somebody who is not connected to the bank, not employed by the bank, just because their spouse is working from home, it could be a very, very serious offense. So all this needs to be considered. I'm using the example of the bank because a lot of information is stored by the bank. And I actually know some of their workers, they work from home. Apart from the tellers, whatever you see when you go to the bank is not really the bank. There are people behind the scene. So those people who are behind the scene now are working from home. How safe is our data? How safe is our money? We saw a scenario where a bank was hacked. I think it was last year, and money was sent out to different people. We saw a scenario where I think Safaricom was hacked and airtime, M-Pesa was flying everywhere. I wasn't lucky to be one of the people who received the M-Pesa, but yeah. How safe is the data when people are working from home? That needs to be considered. Now, what we have right now in Kenya that came as a result of change in technology, we had the Computer Misuse and Cybercrime Act. I've seen a number of cases in court where people have been accused of misusing the computer. There's a particular guy who was accused of, there's a way he used to use technology and he would reproduce ATM cards. He was a Mzungu. He would reproduce ATM cards and actually withdraw money from people's accounts. So this person was charged under this act of computer misuse. In the recent times, we have had people going online, posting stuff that was not good, and some of them had consequences that were not good. I've not really seen somebody who has been sued successfully for misusing. I'm talking in a civil setup, not in the criminal setup, because the criminal setup, we have many who have been sued under the Cyber Crimes Act. But for computer misuse on a civil setup, I haven't seen somebody who has sued successfully. But we have the online, everything is online these days. Even when somebody wants to abuse you, they just go online and abuse you, and then they say it wasn't meant for you. It's an actual emerging trend that the HR professionals need to know about, because you have data for people. Data can be misused. Like, for example, you find yourself receiving promotional messages. Somebody is just sending you, we have a cloud We now have a cloud for lawyers. You can store your documents there. And then you're wondering, who gave out my information? Who gave out my phone number? Sometimes you are even addressed by name. As HR professionals, you have to be aware that if you give out information of your employees, you could actually be sued. Your company could be sued, and a lot of money will be paid. So what is the purpose of the Computer Misuse and Cybercrime Act? We are going to abbreviate it as CMCA Act. Establishes a legal framework in Kenya to address various cybercrime committed using computer systems and digital platforms. It aims for the timely detection, prevention, and investigation and prosecution of cyber-related offenses. So as an HR professional, you can find yourself in a bad place because you gave out somebody's information and that information was used in a bad way, and that person suffered a loss. As, for example, you receive a lot of CVs. These CVs, it's sad. Those days, they used to be dumped in the dustbin. Like maybe they advertise for 3 positions and then 50 people submit their CVs. At the end of the day, they are dumped. The proper way to actually deal with it then was for them to be shredded. Now, we have CVs being sent to the email. That information is in your email. If somebody accesses your email, will they be able to get people's data? And if they misuse that data and it's actually found that the source of information was your email, you could actually be in deep trouble as an HR professional. So you have to have ways of protecting the information that you receive in your capacity as an HR professional so that you are not you don't find yourself in a place where you have infringed on somebody's right to privacy because of your job. What is the impact of this act in workplaces? With the proliferation of the hybrid and remote workplace models, the CMCA provisions are highly pertinent for ensuring the security and integrity of company data and systems accessed by employees from various locations. So, if you're given the password to access the systems of your company, how best are you supposed to protect it? Because this information is not supposed to go out there to the public. As an HR professional, it is now important for you to conduct trainings for your employees because maybe you're working on site and there are various employees who are working off site. It is important for you to educate them of the necessity to keep this information under lock and key, even when they're out there. What will that necessitate? It means if somebody is working from home, my recommendation is they shouldn't be using their personal computers to work from home because a personal computer can be accessed by somebody else. If it is a work computer, then something happens and the company information is leaked, you can actually have a way of tracing it to who had that specific computer and who leaked the information. But if somebody is working on a personal computer, maybe the computer was stolen and the information was taken out of your company information, how are you going to be able to trace it? It might be a bit difficult, and then somebody can have a defense and say, it was my personal computer. So it is important for you to educate the employees of this. Now, prohibited activities under the Act. The Act criminalizes actions such as unauthorized access to computer systems, interference or destruction of computer data, cyber harassment, and publication of false information. Are your employees educated about this? Maybe you know it, but what do your employees know? Do they know about this information that they carry to their homes, to their hotels? Maybe they decide, oh, I'm going on a trip, but I'll still work. Because now Even with the courts these days, I could be in Dubai and I am attending court in Kenya because we are now working through the e-teams. So in case, say, I was employed and I have information of clients for my boss, and I travel, I go to wherever, I decide to work online. I need to be informed that I'm not supposed to destroy that data, because there are people who will destroy the data intentionally. They have access to the system. They know the bank has 1,000 customers, but I can make 500 accounts disappear, and they can actually do that. So in case that happens, what do you do as an HR professional? Are they informed about it? If they have this data, do they have the right to harass people online because they have their data? Oh, I know you don't even have money in your account. You're just here bragging for us. Are they entitled to do that? Of course not. What are the employees' obligations? Under the Act, it is an offense for employees to unlawfully destroy electronic messages or intentionally withhold electronic payments delivered in error. Sometimes somebody pays for an item and they were supposed to pay somebody else. We see that happening in M-Pesa a lot of times. An employee is supposed, for example, if they're in that position, they are supposed to actually give back. Like they are supposed to accept for the money to be refunded to the person who paid it unknowingly or by mistake. Employees are also explicitly required to relinquish all codes and access rights to their employers' computer networks or system immediately upon termination of employment. For example, I'm going to keep using the example of the bank. Somebody has the login codes for maybe ATM cards or something. When they leave work, or maybe they've got a new job, they are supposed to relinquish all this information. And what normally happens, because these are smart people, they have gone to school for this. The proper thing to do is to have the codes changed. But if they are not changed, that person can access the system again. So in case the employee refuses to give out this information, what happens? Of course, the employer can sue them. You as an HR professional, you can write them a demand and ask them for those codes. And if they do not submit them or relinquish them, you can inform your employer of their right to take legal action against them. HR policy formulations. HR departments must formulate and implement robust cybersecurity strategies, frameworks, policies, and procedures that specifically address acceptable use of company IT resources, data, security protocols, and clear disciplinary action for the Act's violations in remote and hybrid settings. As an HR professional, if you are privileged to work in a space where people are working online, you need to establish policies for this because it's an emerging trend. It's something that is changing. You need to do your research and see those that have gone ahead of us, how are they handling it? In case somebody is handling data, company data, and they're working from home, what are the policies that are in place to make sure that that data is not misused, that data is not shared out there, that data is not exposed to the outside world? You need to come up with those policies that are in line with your company setup, because companies are different. You may not be in a space that is dealing with this right now, but maybe in the future you could get another job, or your company could change its systems and actually adopt this kind of hybrid setup. So what will you do as an HR professional to ensure that your employer is protected from lawsuits, because people are actually suing for data breach? So make sure rather, I would advise that you inform yourself of policies that are in place in the big workspaces that have both systems of work, the hybrid or working, remote working, so that you're able to come up with policies for your workplace, because that is your job. That is why you were hired. Your employer may not know, but you're lucky to know. And it's good you've taken this step to attend a training like this. Now, we are in the age of the aliens. We are in the age of AI. We are in the age of artificial intelligence. How is that going to affect you as an HR professional? We have not embraced AI fully yet. People are still afraid of AI, but it is coming, it is with us, and it is changing everything. In this segment, we are going to explore the legal compliance challenges and opportunities arising from integration of artificial intelligence into human resource functions. What do we have in Kenya? What do we have in Kenya as we speak? Because AI is something that has just started maybe 2-3 years ago after the COVID. COVID was a catastrophe, but it was a blessing in disguise because it gave room for change, for development of technology, to the point that now we have artificial intelligence, like something that maybe I am not able to think of, a robot will tell me what it is. Before, as lawyers, we used to be buried in books, like you're looking for page this. Even when you're writing your submission, you are looking for page this in a book. And if you don't have that book, you have to buy the book. We used to have a way of cases being reported, books were compiled and then sold. Then slowly, the Kenya law reports became Kenya law reports. It is now electronic Kenya law reports. You can now access information about a case at the comfort of your home. It changed the dynamic completely, because now we didn't have to go buy the books. We could just log in into the law report and then we access information because we needed this information. Then later, COVID happened. Then we started attending court online. Those days, we would have to carry big books to the court to show the judge, I found this. Of course, the judge knows where it is, but you have to show him somehow. Right now, even the judges can just take their phones, they're in court, they take the phone, they scroll, ask AI, and then AI will tell them, this is the position. You know, it's that simple. So as an HR professional, what do we have in Kenya as we speak? We have the Kenya National Artificial Intelligence Strategy 2025 to 2030. There's a strategy of incorporating this AI in our workplaces that the government is working on. What we'll talk about that a little bit. We also have the draft KEBS AI Code of Practice. KEBS is the Kenya, Kenya, wait a minute. Kenya Bureau of Standards, yeah? Kenya Bureau of Standards is establishing standards through which AI has to be used, because right now AI is being misused actually. I'm talking to you right now, and then tomorrow my image could be used to say words that I did not say. We've seen that a lot, especially happening to politicians. You see somebody, you see their face, it looks familiar, then they are talking things that they never said in the first place. Then when you look closely, you realize this is an image that has been made with AI. It's going to be a real problem, but somehow we will find a way of dealing with it. So how is AI affecting HR functions? Right now we have workplaces which are doing automatic recruitment and application and applicant tracking systems. People are developing systems whereby the robot is able to look through all the documents. For example, you're receiving all these CVs, 1,000, you want only 2 people. The AI will be able to tell you who is more qualified, of course, depending on their writing skills, for you to be able to call them for an interview so that you don't waste time calling each one and everybody. You have requirements in the advert. You feed in information. Kindly search the data and show me the suitable candidates for this job in line with my advertisement. The AI will be able to do it in a split second, like in 2 minutes. Something that would have taken 5 people to do, one robot is able to do it in split seconds. CV screening and candidate shortlisting. This is also in line with just what I just talked about. You have a pool of CVs, it will screen the CV for you. It will tell you, don't waste time calling 50 people to the interview, just call 3. And then you call 3 to the interview and choose 1. It's as simple as that. Before, ilikuwa, who do you know? AI doesn't know nobody. AI doesn't know anybody. If you tell it, give me 10 qualified people, it will give you 10 qualified people. It will not say, oh, your name is matching with the name of the HR manager, so you must know each other, so let me give you an opportunity. No. This will actually equalize the recruitment platform if it is followed properly. It can actually equalize it because now we do not have that space. Performance analysis and feedback generation. For example, we see in most workplaces where they say you have been put on probation for 6 months and then you will do an analysis of your performance and then you'll be told whether you're going to continue with us or not. So how is the AI going to help you as an HR professional? You do performance analysis as an HR professional. Now, if you are doing, say, performance analysis for 100 workers, they submit their reports. Rather, you receive the reports of their performance. AI will be able, if you feed that information in the system, AI will be able, in a split second, to tell you who has worked best, who has performed best in 4 months. You will not have the stress of going through all the reports and seeing, kizungu ya nani ni mzuri or something. No. AI will be able to tell you in a split second. It will save you your time. You have 50 workers, 20 underperformed, they need to pull up their socks. It will even be able to give you an average. Did they improve? Did they go lower than what they did the last report that you had? It is able to store all this information and actually do comparison on your behalf, which will make your work easier as an HR professional if you embrace it. Automated payroll processing, of course, this should be easy. Those days, the accountants were, or the payroll officers, sorry, not the accountants, they are in the system every day feeding in, this person did not take their leave, this person worked overtime. But if you have a system established in your workplace whereby, as an HR, your job is to wake up in the morning, click who attended work. The system already knows when they're supposed to go on leave, whether they have gone on leave or not. So when the payroll is being processed, it has all the information. It's in a split second. You don't have to go through all the draining exercise of typing, of looking through the papers, because imagine you already have the clicking system with the fingerprint. It is synced to the computer. So it already knows this person came to work at this time, they left at this time. So automatically, the overtime will be processed by the AI. If they didn't go on leave, it will already show in the system that, they worked for all the 12 months. So when it's calculating the pay at the end of the year, it already knows this person is going to be paid in lieu of leave. We even have AI-powered chatbots for employees' queries and support. You can establish that. We can see it from even the systems that the government has set up. For example, the Ardhi Sasa, which is they are trying to now migrate all the landowners into one portal so that wizi wa mashamba can reduce. So what happens when you go in that system, the moment you want to log in, there is an automated chatbot there. It is there. It is asking you, like, do you have, it's always popping like this. Do you have any question? And then you find that there are frequently asked questions. So as an HR professional, you can advise your employer to come up with a system whereby, for example, we have sexual harassment policies, yeah, in workplaces. You can come up with a system whereby if somebody has a question on sexual harassment in the workplace, they are able to log into that space and their questions are answered. They don't really need to come to the HR and ask, oh, what happens in case of this? There's those frequently asked questions that can be able to be answered without you inputting yourself physically. I was just giving the example of sexual harassment, or maybe leave forms or whatever. Somebody logs into the system and then they can see something popping up, frequently asked questions. When can I take my leave? Where can I fill the form? Where can I ask for my overtime and all that? The frequently asked questions can be very helpful and in saving your time as an HR professional. Predictive analytics for workplace planning and retention. Now, as an HR professional, you always plan your fellow employees. Yeah, you have their duties planned. In this season, you need 100 workers, and then in the next season, you will need 500 workers. So if you have incorporated your data, your information on the seasons, depending if your work has those kinds of that kind of dynamic, you are able to know. AI will prompt you and say, in 2 weeks, you will need to reduce your workforce because you have less work during the coming season. It will help you as an HR to plan your employees, to plan who is supposed to work where, or maybe you have a scheduled reshuffle. Maybe you're working in a place where workers go working in different departments. There are places that work like that. So it will prompt you and be able to tell you, in November, so and so is supposed to move to this and this place, to this and this department, to a different department. And this AI, if you actually set it, it will send a reminder to the worker. You don't need to go writing letters saying, oh, it is now 2 weeks you've been working in this department, it is time to move. No, you can set up a system in a way that it notifies the workers of the reshuffle. This can be done. So AI challenge comes when it goes, AI's challenge is data protection. How are you dealing with the data that you have shared with AI? For example, we have the famous ChatGPT. There are people who have actually shared so much information about themselves with the ChatGPT to the point that the ChatGPT actually understands how this person thinks. We even have Bixby, I think it's called Bixby. We even have the iPhone one, the Siri. You find Siri knows everything about the owner of the phone. So in a situation where you have fed this information into the AI, whichever robot you decide to use, because they are being developed every day. You've shared information about your employees because it is helping you do all these things. It knows all your employees even better than you, because you cannot keep track of 1,000 people, but it can. It is able to compartmentalize to that extent. So how are you going to protect this? How are you going to be able to work with it as an HR professional without putting yourself in problems. It is crucial to align AI tools and their operational processes with the principles and requirements of the Data Protection Act and its accompanying regulations. You know, in Kenya, we have the Data Protection Act. So when you're using these chatbots or whichever AI you're going to decide to use as an HR professional, make sure it is in line with the provisions of the Data Protection Act. Take some time, read the act, because AI is here with us and we are going to use it. Or maybe you're already using it, but make sure in using it, you are in line with the Data Protection Act. Otherwise, your employer will be sued and they will pay a lot of money. People are getting a lot of money because of their data being shared out. As an HR professional, you have to ensure explicit and informed employees' consent is obtained for the collection and processing of their data by AI system. For example, the other day, we had so many people suing nightclubs for taking their pictures and posting them on their Instagram without their permission. So as an HR professional, your employee is going to give you information. When they are filling the form, when they are being employed, incorporate a section. In the online forms, we just normally tick, I agree to all the terms. We don't even read the terms. But make sure they fill a form that says, I agree for my information to be processed by AI. It is important. It will save you, because one day it will happen that their information might be found. For example, they shared information to HR. They don't know that this information is going to be used in the payroll system on an AI system, on an AI bot or something. And then ultimately it will be used. If, for example, it so happens that they don't like it and you did not make them fill that form that says their information, I give my consent for my information to be used in the AI, they could sue you and they would go away with a lot of money. Maintain transparency in how AI is utilized, how it processes data, and how its decisions or recommendations are generated. Now, this means as an HR professional, you just have to study the AI, because if you don't know how it works, how will you explain it to your employee? You're telling me you're going to use my information in AI system, and you're not telling me how those decisions are arrived at. It will be a problem. It will be a problem. So take some time, get information, read up on the AI. If you can take a course, because it's going to affect the way you do your work. It will make your work easier, but you have to do it the right way. Adhere to principles of lawful processing, ensuring all data collection and usage by AI are for specified legitimate purpose. Don't just be analyzing people because you have AI. Why are you analyzing the data? Why are you feeding in this data? Are you just feeding it in for, just to feel nice? Oh, I know how to use AI. No, it should be for a legitimate purpose. If you're doing a payroll, it is legitimate. It is for purposes of making your work easier while processing the payroll. So, so now that we have exploited explored, the area of AI, we still have to be aware of the problems that come with it. Yeah, the problems that come with it, the challenges, not the problems, the challenges and how to be able to deal with them. A synergy with Computer Misuse and Cyber Crimes Act of 2018. With the AI era, we have a challenge of cybercrime. Sometimes you could commit a crime without knowing, but remember, ignorance of the law is no defense. The act directly reinforces the need for robust data security measures when AI systems are utilized. It provides specific penalties for cybercrimes that could compromise data privacy, such as unauthorized access, interception, or disclosure of personal or confidential data via computer systems. So you see, the drafters of the Cybercrimes Act, I think, envisioned that AI would come at some point. Because why? Why the cyber crimes? Why the Computer Misuse Act? They envisioned AI would come. So now that AI is here, you're going to be feeding information about your employees in these robots, in this AI system. And then the AI will process the data. If that data leaks, you could be charged for a criminal offense, let alone the civil one where you have to pay money. Criminal offense, you have to pay a fine or you could be imprisoned. So don't find yourself in that situation as an HR professional, as an HR practitioner. Securing, we look at securing, how to secure AI systems and data. As AI systems handle and process vast amount of sensitive employee data, strict adherence to the Act provisions is paramount to prevent cyber attacks, data breach, and other digital offenses against AI infrastructure or data I beg your pardon, or the data it manages. So take time, read the Act, find out the challenges, and protect yourself from that, because AI processes a lot of information and the information can be manipulated. Maybe you submitted information for purposes of analyzing the performance of an employee, and then that data is used for something else. It is possible. Maybe you're not the only one who has the access to the system. Protect yourself, engage with the Act, and engage with AI as well. The Act provides against computer fraud, identity-related crimes, and interference with data, underscore the necessity for strong security controls, access management, and comprehensive audit trails within AI-driven HR platforms to ensure data integrity and prevent malicious misuse. So if you engage with the Act, the Act I'm talking about is the Computer Misuse and Cyber Crimes Act. If you engage with the Act, you're able to identify where the challenge is. Like, in case this happens, how do I protect myself? Or when I'm engaging with the AI, when I am feeding in this information, how do I protect my company from being sued? Is it safe? Is it worth it? That is another question you need to ask yourself. It will save you time, but is it worth all the insecurities involved? That's a question and a decision that you have to make as an HR professional. Organizational accountability. Companies implementing AI in HR must establish comprehensive cybersecurity frameworks and internal policies that align with the Act to protect both organizational assets and sensitive employee data from evolving cyber threats. Because as the AI is being developed, other people are developing mechanisms of attacking the AI. This information that you share in the AI system, somebody could attack that system and all the information is leaked. It can be a very, very terrible problem for your company. So the company, before you start to use AI in your HR practice, make sure the company has serious frameworks of how they secure themselves from these cyber attacks. Let's not just embrace it without guarding ourselves, because it is a solution, but it can be a problem as well. So the organization has to be accountable. Do they have IT specialists that are actually ensuring that this information as it is shared cannot be accessed by anybody from the outside world. So desist from just putting information in any AI platform. Make sure it is specific. If it can be developed specifically for your company, you can do that. You can do that. Balancing AI and employee well-being. This is an evolving area of ethical and practical consideration, currently undergoing significant research and development because AI is still new. It's probably 2-3 years old. It is still new, so it's something that is changing. It is being developed as we go. And the research emphasizes the importance of ethical, transparent, and supportive AI practices that prioritize employee well-being through clear communication, opportunities for upskilling, and ensuring that AI-driven decisions are audit-ready and non-discriminatory. So, when you're using AI, you have to remember you're dealing with humans. As an HR professional, you are a human resource manager. You are managing human. In as much as the AI is making your work easier, you have to remember that AI is not human. AI is artificial. It's artificial intelligence. It can recommend something to you that does not actually work for your organization. So you have to be able to stand by the decision. When the decision has been made by AI, do you sit back and reason and think, okay, AI has helped me make this decision. If an auditor comes, am I able to explain? Because maybe the auditor will come and the auditor does not understand AI. They do not know that this decision was as a result of feeding information or feeding data into an AI system. So are you able to defend that decision in as much as it was made by the AI? Are you able to sit back and say, the decision made by the AI is actually in line with the Employment Act, is actually in line with the Data Protection Act, is actually in line with the Computer Misuse and Cybercrimes Act. Is it in line with that? So you have to be able to sit back and reason and be able to defend that decision. We have come to the end of the AI discussion. We are now moving on swiftly to our last part, which is a cause of debates in the recent times. These days, we are hearing everything go green, 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 green. Well, green for the trees, green for the grass, green for the dollars. So we are now delving into the subject of sustainable green HR policies. We have been affected by climate change. The green is becoming less everywhere. The green is disappearing everywhere. We are lucky that in Africa, we still have the green. Like as I speak to you right now, across my window, I can see a lot of green. But maybe in 5 years, people will come and it will all be concrete. I don't know. So as an HR professional, this is a subject that affects you whether you know it or not. The world is changing. The world is becoming more aware of the necessity to maintain the green. So what is green human resource management? Green human resource management is a strategic integration of environmentally conscious policies and practices into core HR functions. This encompasses areas such as recruitment, training, performance management, and shaping the overall workplace culture, all aimed at supporting and achieving the organization's broader sustainability goals. Everybody is moving towards sustainability. How sustainable is your organization? How sustainable? How are the decisions of your organization impacting the green? Everybody is becoming environmental conscious. They are conscious of their environment because once the environment is bad, we get sick. Many people are getting sick because there's no much green around them. What are the core objectives of a green human resource management practice? This practice is aimed at promoting environmental awareness and responsibility among employees. For example, we see the government has tried to establish days like the green days when we have the World Environmental Day. Normally, as the Environment and Land Court, they always engage in a practice of planting trees all over Kenya. We even had the other day when people took choppers to go and plant trees in Kilifi and whatever. I think it was last year but one, where the MPs were assigned different locations to go and plant trees. Whether the trees were planted, that's a different question. Whether the trees still exist up to today is an entirely different question. So the government itself is trying to promote environmental awareness, and it's trying to put that responsibility. I know in the times of Moi, I hope I am right, where they used to say you cut one tree, you plant two, right? I don't know what happened to that. Even me growing up, I was always told when you cut one tree, you plant two. So as an HR professional, you have to start making your fellow employees aware of the importance of the environment around them, of the importance of the green around them. Your policies should aim at reducing waste generation, energy consumption, and overall carbon footprint in workplace operations. For example, in Kenya lately, we have so many people harnessing the power of green energy. We have a lot of solar-driven projects. We find in a place where normally we'd use electricity from KPLC, you find at least 70% of the electricity being used in a building is from the sun, because we are lucky to have the sun almost every day in Africa. So as an HR practitioner, make it a habit to ask or to recommend to your employer to use green energy. We have many hotels here right now. They are using solar. They are running on solar, which actually reduces the carbon emission from generators. Even the hydroelectricity, they use fuel to produce this. It doesn't make sense using fuel to produce this electricity. Sorry, my light went off. So make it a habit. Make it a habit to incorporate this in your workplaces. Actively encourage eco-friendly behavior and sustainable practices among the workforce. Use less paper. Use more of your computer, because paper comes from trees. And for the paper to be made, the trees have to be cut down, which is a bad thing. Support the company's broad environmental, social, and governance goals and reporting requirements. As an HR professional, what are your company's goals when it comes to environmental, social, and governance? We see CSRs. We say, oh, we are giving back to the community. How does your company give back to the community? Does it involve maintaining the environment? Does it involve making the environment better? As an HR professional, this should be one of your aspirations, so that the company that you work for can actually be able to hit those requirements. The hotel sector these days, they have a strict sustainability requirement. They have actually withdrawn licenses of hotels for greenwashing. Like when they're writing in their websites, they say how they are all about green energy, green everything, they're supporting, they plant trees. And then when an assessment is done, it is found that they have actually not done the things that they say they have done in line with making the environment better or sustaining it. So licenses have been, we have the TRA, Tourism Regulatory Authority. Licenses have been withdrawn from companies that are actually not, that are greenwashing their customers. It is now a requirement if you're bringing tourists from Europe that your hotel passes the test. And if they come and do the assessment and find that you are greenwashing them, they don't give you guests at all. They refuse because they are now taking it seriously. I think it has affected them in Europe. They have destroyed their environment and now they are trying to make Africa help them to better their environment, which is good for us because we were going their way. Everything is becoming concrete. It's becoming a concrete jungle, as they say. So as an HR professional, it is good that you advise your employer to incorporate the green into their practices. What are the core objectives of green human resource management in practice? It promotes environmental awareness and responsibility among employees. Conduct trainings. Let them know the importance. Reduce waste. Oh, sorry, did this repeat itself now? Reduce waste generation, energy consumption, and overall carbon footprints in workplace operations. Actively encourage eco-friendly. Oh no, it repeated itself. We'll go to the last one. Embedded sustainability principles deeply into the organizational culture and inform all HR decision-making processes. If it is made a culture, then it can be done. We have people who just litter the environment anyhow in your workplace. Do you have those kinds of people? Do you have punishment for those kinds of people? How can you incorporate green HR policies? We have a practical example here. You offer remote work options for significantly reducing employee-related emissions. For example, if I have to come to work, I'll probably drive my car to come to the workplace, or I'll probably board a public service vehicle to come to the workplace. What does that mean? The vehicle is using fuel and it is emitting fumes into the environment. If I work from home, I wake up early, take a shower, sit on my computer and get the work done. The environment is kept better because I didn't use my car to go to work. Providing targeted training programs on green practice, environmental conservation, and sustainable operational procedures. As an HR manager, encourage your employer to have days to train the employees on the importance, on the practices. Use, for example, do not litter. When you litter, the environment is destroyed. Okay, when you use plastic, like in Kenya, at least the government has 90% managed to deal away with plastic, though we still have them in some places, but they are very few compared to how it was. So the environment is now better because we get better food, we plant better crops, and they grow properly because there's no plastic everywhere. Promoting the use of digital files and paperless processes to minimize waste. For example, we have moved from the era where people were submitting CVs and job applications in physical form, though we still have that in some government when they're advertising for county jobs, they say you must bring your documents and put them in a box somewhere. That is a lot of paper which comes from trees. And then once that paper comes from the trees, the CVs are dumped and then they are burnt, more fumes to the environment. So as an HR professional, you can adopt a system where you're using digital files. When you have employees, you don't have to have the big file, like, like everybody has a file and then they are piled up somewhere and they are gathering dust, more problems to the environment. You can have a paperless system. Encouraging employee participation in corporate social responsibility initiatives focused on environmental protection and green volunteerism. When you see maybe on a public holiday which is stipulated for planting of trees, does your company actually participate? Do you actually get trees and plant them, or do you just say, oh, it's a holiday, we are going to sleep? So as an HR practitioner, you should encourage employees to participate in those initiatives. Creating formal, documented green workplace policies that guide sustainable behavior and practice across the organization. Yeah, create this documentation. Like, we had one tree when we moved into this place, for example, if this is your workplace, and we make it a point to plant 3 trees every year, because the space is small. We can do 3. So you have a documented documented green workplace policies. Or maybe you can even reward them for planting the trees. I don't know. Why green HR policies matter? What are the benefits of green HR policies? Strategic alignment. It helps align HR functions with the global climate change and broader sustainability goals. So we have said that the world is changing, the climate has changed, it has affected us immensely. So for us to be able to bring back the glory of the globe, we need to help each other. We need to have the HR come in and actually make this happen. If they encourage the employees, it will be done. It enhances employer brand. For example, it significantly enhances the employer's brand, attracting and retaining eco-conscious talent. For example, we see companies sponsor tree planting exercises. We see more companies sponsoring marathons than tree planting exercises. So you can stand out. Let your company stand out instead of sponsoring a marathon. Well, marathons are good for health, but you can encourage your company to sponsor a tree planting exercise. It will enhance the brand. It is in line with the global concerns on climate change, and it will give your company a good picture out there. It improved employee engagement. It boosts employee morale, engagement, and commitment by fostering a sense of purpose and social responsibility. Imagine if everybody is environmentally conscious, if they are conscious about the environment in which they live, you will have a better working space. You breathe in fresher air, though we have the air conditioning everywhere, but when you go out there, when you breathe in fresh air, you can tell this is fresh air. So if everybody is environmentally conscious, it boosts their morale. Like, even you as a person, if you know you planted this tree and you see it grow, somehow you'll feel nice about it. So yeah, I planted this tree, if you're conscious of the environment anyway. It also helps to comply with regulatory and reporting requirements. It assists companies in meeting evolving environmental reporting requirements, standards, and regulatory expectations. For example, I was telling you an example of the hotels, which are required to show that they are actually promoting the environment, making it better. If it is done through the HR, you're actually helping your company to comply with those requirements. Cost savings and efficiency often leads to operational cost saving through reduced energy, water, and waste consumption as an indirect benefit. For example, if I work from home, I don't spend money on fuel. And if I don't spend that money on fuel, my car does not emit gases to the environment, if the gases are not emitted to the environment, it means you're breathing in better air, right? So it's an indirect benefit. What is the Kenyan context for green HR practices? The current legal status. While a specific comprehensive legal mandate for green HR has not yet been formally established in Kenya, several related trends are distinctly evident. Observable trends in Kenya, we have increased adoption of remote work and digital system, contributing to reduced carbon footprint. Growing emphasis on training and awareness programs related to environmental responsibility within organizations. This, like for example, we've talked about it today. I hope you can tell your boss about it tomorrow. Oh no, on Monday, because you're not working tomorrow. If you're working tomorrow, you can do that. So I believe the people who have attended this training today have acquired a level of awareness of the importance of green HR practices. Rise of employee-led sustainability initiatives and green committees within workplaces. I don't know how practical this is for your workplace, but you can establish it because, I mean, HR managers can change a workplace. So this can be one, like you can be one of those HR managers that say, yeah, in the year 2025, I actually established an initiative where nobody litters the environment. So I am proud to be one of those. Supporting national frameworks and policies, we have the Climate Change Act of 2016. Take some time to engage with it and see how what the government had in mind when it was formulating this act. We have the National Sustainable Waste Management Policy. Now, in most areas, especially in the urban areas, we have a problem of waste management, and the government has tried, but the government cannot do it all by itself because it goes back to the individual. The person who is doing the waste management is probably paid by the government. They are doing it because they are paid. If they are not paid, they will not do it. They will not go to work. They will not go collect that waste and dispose it in a proper way. So let's try and take it as an individual responsibility. Kenya Vision 2030, do you know we are just 5 years away from Vision 2030. I don't know whether they are going to push it to make it Vision 2040. Anyway, Kenya Vision 2030, it includes environmental sustainability as one of its pillars. So we have come to the end of our training, our discussion, not the training. I'm going to now stop sharing my screen and take on a few questions if there is any.
Hello.
Yes, hello. Okay, if you want to take a question, please raise your hand so that we can do it in an orderly manner. Kipta Bay. I hope I said your name correctly. Go ahead.
I have a question on the place of a labor officer in county governments. Now that the county governments are semi-autonomous and they have the public service boards, where does the employment officer come in issues of employment in county governments? That is number one. Number two is on disciplinary process. That after maybe the delay, the times between the date of issuance of shokos, and maybe termination of the case after the disciplinary process. and you find that the employee has caused a delay maybe over to a maximum of exceeding 6 months. How do you deal with it? And then lastly, maybe an update on your presentation. There is a new Disability Act 2020, which was signed in just recently by the president. So I think it gives more light on the rights of persons with disability. Thank you.
Okay, thank you so much. The first question on, no, let's do the second one on the time lapse between issuance of notice to show cause and when the case is determined. As an HR policy, as an HR manager, I'm sure your company has an HR policy relating to disciplinary hearing, right? And it is not, in my opinion, it is not proper for a notice to show cause to be issued today and then wait for the disciplinary hearing after 6 months. Remember, even when you're giving the warning letters, they're only valid for 6 months, right? So if a notice to show cause is given, it should indicate you must show cause within this number of days. Say 14 days, show cause why you shouldn't be subjected to disciplinary hearing. And when the show cause is given and the person responds, as an HR manager, your mandate is to tell them whether they're actually going to face disciplinary hearing or not. You just don't keep quiet and then wait after 6 months and then you send them for disciplinary hearing. Otherwise, you'll have to issue another show cause letter for it to make sense. Otherwise, in the courts of law, they will not take that. And then on the update of, I just want to check it out. All right, thank you so much for that update. I see the Persons with Disabilities Act 2025. I'm going to update the slides before they are sent to you because I know you're going to receive all this information and incorporate the new act. The question about the county labor officer, I don't think I understood that question. Maybe if you could repeat it.
Sorry, I got distracted.
The question of the county labor officer, I did not understand the question.
Yes, we have the labor officers, which are employees of the national government.
Yes.
And they have been posted to the national government offices.
Okay.
And then now we have employees employed by the county government, an independent semi-autonomous government body, which is the county government, and they have their county public service board. What is the nexus between the labor officer from the national government and the employees of county government?
Oh, okay. Now, in my opinion, maybe then you can add more to this. In my opinion, please mute. Please mute. Thank you for assisting us with that. So for the employees, for the labor officers that have been employed by the government, those ones are dealing with the general public. Like if somebody has a complaint against their employer, they can go there. But the ones on the county service board, that's a completely different setup because we have the devolved system of government. I don't think they are authorized to handle cases that are coming from the general public. I don't think they're authorized for that. Jen, your hand is up.
Yes, hi, how are you?
Fine, thank you, Jen.
I had a question in regards to disciplinary process.
Yes.
Say you're working in a private institution and the board of managers instructs you to terminate an employee with immediate effect, without following due process, and you're given a deadline in which that should be done. Maybe they tell you by today evening this person should be out of the institution. How would a HR personnel handle such a situation without getting themselves in trouble with the board?
Okay, now, in my opinion, you are employed by the board, no? As an HR practitioner. So if they say that you must terminate the services of this person, it is proper to write to them and tell them that they need to follow due procedure. And if they are not willing to follow procedure, they should write to you confirming that they are the ones taking that decision and that they will pay that person in lieu of the notice. Because of course, it's going to backfire. And at the end of the day, you need to protect yourself. So everything must be in writing. You protect yourself by writing to them and ask them to write to you back with their decision. Because ultimately, if it is taken to the labor officer at the court, they are the ones going to pay. It's not you going to pay. So you need to protect yourself from that.
Okay, thank you. And another question is in regards to private institutions. You said the employee has a right to be represented by a respective union. Say, can this employee during a disciplinary process be represented by that union representative in private institutions?
No. During a disciplinary hearing, they are not represented. The union officer can attend. They can attend the disciplinary hearing, but they are not allowed because the person who has been accused of something must answer personally. Because this union officer was not at work when whatever was happening. So there is no, and the union officer is not an advocate. Even advocates are not allowed to attend disciplinary hearings. We are not allowed to do that. We can only just be present, but we are not allowed to speak.
Okay. Lastly, is in terms of overtime pay. We had a policy for that in our organization, but the board of governance scrapped it off from the policies. So would it be wise to put it in our contract agreement between the employer and the employee that working hours it's exclusively at your discretion?
No, you cannot say working hours is exclusively at somebody's discretion. Just don't make people work overtime if you're not going to pay them for it. Because whether it's in the policy or not, if they sue, they will get the money. So if they are not going to be paid, then they should not work.
Okay, thank you.
Yes. Welcome. So if that is all, I would invite Dan to close.
Maureen, lastly, sorry, supposing an organization would like to engage you in training of its employees, or rather of its management, is there a way that we can reach you?
Thank you, Dan. Thank you, Jane, for that. Yes, there is a way you can reach me. there's a way you can reach me, but I think Dan has my email. I think you received an invite, right? Through the email.
Yes, he did.
Yeah, so I'll ask him to send you my email.
Thank you.
Is that okay?
Yes.
Okay, thank you so much. So we'll have to close. We'll have to close. You can leave the meeting at your pleasure. The admin is going to end it. Thank you so much for your time. We hope to see